The Markets in Financial Instruments Directive 2004 EC is subsequently amended as a European Union law that provides harmonised regulation for investment services across the 31 member states of the European Economic Area. The main objectives of the directive are to increase competition and consumer protection in investment services. As of the effective date, November 1, 2007, it replaced the Investment Services Directive. MiFID is the cornerstone of the European Commission's Financial Services Action Plan, whose 42 measures will significantly change how EU financial service markets operate. MiFID is the most significant piece of legislation introduced under the Lamfalussy procedure, designed to accelerate the adopting of legislation based on a four-level approach recommended by the Committee of Wise Men chaired by Baron Alexandre Lamfalussy. There are three other Lamfalussy directives: the Prospectus Directive, the Market Abuse Directive and the Transparency Directive. MiFID retained the principles of the EU passport introduced by the Investment Services Directive, but introduced the concept of maximum harmonisation, which places more emphasis on home state supervision. This is a change from the prior EU financial service legislation, which featured a minimum harmonisation and mutual recognition concept. Maximum harmonisation does not permit states to be super-equivalent or to gold-plate EU requirements detrimental to a level playing field. Another change was the abolition of the concentration rule, in which member states could require investment firms to route client orders through regulated markets. The MiFID Level 1 Directive 2004 EC, implemented through the standard co-decision procedure of the Council of the European Union, and the European Parliament, sets out a detailed framework for the legislation. 20 articles of this directive specify technical implementation measures. These measures were adopted by the European Commission, based on technical advice from the Committee of European Securities Regulators and negotiations in the European Securities Committee, with oversight by the European Parliament. Implementation measures in the form of a Commission directive and Commission regulation were officially published on September 2, 2006. Scope of MiFID: to determine which firms are affected by MiFID and which are not. MiFID distinguishes between investment services and activities, and ancillary services. More detail on the services in each category can be found in Annex 1 Sections A and B of the MiFID Level 1 Directive. If a firm performs investment services and activities, it is subject to MiFID in respect both of these and also of ancillary services. However, if a firm only performs ancillary services, it is not subject to MiFID. MiFID covers almost all tradable financial products with the exception of certain foreign exchange trades. This includes commodity and other derivatives such as freight, climate and carbon derivatives, which were not covered by ISD. That part of a firm's business that is not covered by the above is not subject to MiFID. Under MiFID, Celent estimates that the three largest EU jurisdictions will surface over 100 million additional trades annually. Spending will increase as well, but at a slower rate, from a 38 million yearly to close to a 50 million, according to figures published by Celent January 23, 2007. Key aspects of MiFID: authorization, regulation and passporting. Firms covered by MiFID will be authorized and regulated in their home state. Once a firm has been authorized, it will be able to use the MiFID passport to provide services to customers in other EU member states. These services will be regulated by the member state in their home state. Client categorization: MiFID requires firms to categorize clients as eligible counterparties, professional clients or retail clients. Clear procedures must be in place to categorize clients and assess their suitability for each type of investment product. That said, the appropriateness of any investment advice or suggested financial transaction must still be verified before being given. Client order handling: MiFID has requirements relating to the information that needs to be captured when accepting client orders, ensuring that a firm is acting in a client's best interests and as to how orders from different clients may be aggregated. Pre-trade transparency: MiFID will require that operators of continuous order matching systems must make aggregated order information on liquid shares available at the 5 best price levels on the buy and sell side. For quote-driven markets, the best bids and offers of market makers must be made available. Of Directive 2004/EC, the European Commission is due to submit a report to the European Parliament and to the Council on extending pre- and post-trade transparency requirements to transactions in financial instruments other than shares by October 2007. Post-trade transparency, MiFID will require firms to publish the price, volume and time of all trades in listed shares, even if executed outside of a regulated market, unless certain requirements are met to allow for deferred publication. Best execution, MiFID will require that firms take all reasonable steps to obtain the best possible result in the execution of an order for a client. The best possible result is not limited to execution price but also includes cost, speed, likelihood of execution and likelihood of settlement and any other factors deemed relevant. Systematic internalizer. A systematic internalizer is a firm that executes orders from its clients against its own book or against orders from other clients. MiFID will treat systematic internalizers as mini exchanges, hence, for example, they will be subject to pre-trade and post-trade transparency requirements. Fragmentation of market. Although MiFID was intended to increase transparency for prices, the fragmentation of trading venues has had an unanticipated effect. Where once a financial institution was able to see information from just one or two exchanges, they now have the possibility to collect information from a multitude of multilateral trading facilities, systematic internalizers and other exchanges from around the European Economic Area. This results in an additional amount of work to benefit from the transparency that MiFID has introduced. Dealing with fragmentation, the number of additional pricing sources introduced by MiFID means that financial institutions have had to seek additional data sources to ensure that they capture as many quotes trades as possible. Numerous financial data vendors have worked with the MiFID Joint Working Group and regulators to make sure that they are able to help financial institutions to deal with the fragmentation and benefit from the increased transparency, while helping them to fulfill their new reporting liabilities. Transposition of MiFID. MiFID and its accompanying implementing directive were transposed in full and on time, with minor exceptions. The European Commission has published a transposition table linking to lists of national provisions which transpose directives. MiFID in the United Kingdom. The Financial Conduct Authority is responsible for the regulation of the securities industry in the United Kingdom. It has incorporated MiFID into its Handbook of Rules and Guidance. MiFID in France. The French legislature has implemented MiFID by modifying the French Monetary and Financial Code, in particular by Ordinance No. 2007-544 of April 12, 2007, and the Decrees 2007-901 and 2007-904 of May 15, 2007. The Financial Market Authority has also applied MiFID to its general regulations. MiFID to MiFIR. In April 2010 CESR issued consultation papers on MiFID review. The consultation period was short and ended on May 31, 2010. There was a day of open hearings in Paris on May 17, 2010. Public responses to the consultations are now available, although a number of institutions submitted confidential responses too. On December 8, 2010, following a public hearing held in September 2010, the European Commission released a substantial public consultation relating to the review of MiFID, accompanied by a press release and frequently asked questions. The public consultation period was scheduled to close on February 2, 2011. On May 26, 2011, the Commission was reported to be working to present its proposals before the end of 2011. On October 20, 2011, the European Commission adopted formal proposals for a directive on markets in financial instruments repealing Directive 2004/EC of the European Parliament and of the Council, and for a regulation on markets in financial instruments which would also amend the proposed European Market Infrastructure Regulation, EMIR on OTC derivatives, central counterparties and trade repositories. In March 2012, MEP Markus Ferber suggested amendments to the European Commission's proposals, intended to strengthen restrictions on high-frequency trading and commodity price manipulation. The Association for Financial Markets in Europe's formal response to Ferber particularly cited concern with a requirement that all algorithms run continuously, as this would preclude the use of broker algorithms to execute client orders. The creation of the Organized Trading Facility rules have also caused concern because of their proposed ban on proprietary trading and broker crossing networks, which would prevent brokers from using their pools to unwind risk on behalf of a client or the bank itself. See also, Alternative Investment Fund Managers Directive, European Company Law, Institutional Investor, Investment Company Act of 1940, Reg NMS, UK Company Law and German Company Law, Undertakings for Collective Investment in Transferable Securities Directives, Notes. References, MiFID 2.0. Casting New Light on Europe's Capital Markets, Centre for European Policy Studies, external links, EU legislation summary, text of the directive with headers, European Commission MiFID pages, MiFID 2 discussions in Paris, CES guidelines and recommendations, FSA MiFID pages, T2S project of the Eurosystem, MiFID 2 event, London, author of MiFID 2 speaks at event.